Hi, I'm Craig Hirsch.
And I'm Michael Hill, and we're board-certified wills, trusts, and estates attorneys at the Shepherd Law Firm with our main office in Fort Myers, Florida, and a satellite office in Naples.
Now, what Michael and I are going to present to you here is a short video on Florida residency and estate planning. In particular, you might be updating your estate plan to Florida law, or you might be creating a new plan. And these are the things in this video that we want you to think about, both in preparing for that planning and before your initial consultation with us. So you might be wondering why you need to update your documents. You may have just become a Florida resident, for example. You might have moved here from New York or Ohio or Michigan or some other northern state. Well, know this, every state's laws are different. New York's law is different than Florida law. Ohio's laws are different than Florida law. And if your documents are from up north, and particularly if they're very old, if you haven't updated your documents in a long time, and even if you have, if they are drawn in another state, if they're subject to that state's laws, then you want to make sure that a Florida attorney reviews your documents and that they are compliant with Florida law and they don't have any unintended consequences. Now, one of the things that we see very, very commonly, and this is even after our clients, their northern attorneys have said, well, you know what, your documents are just fine. All you need to do is update them to Florida law. Well, that's not always the case. Sometimes it's a little bit more complicated than that, and that has to do with your Florida homestead. Now, you may be familiar with the Florida homestead exemption, the property tax exemption that saves you a little bit of money. And you also might be familiar with the Save Our Homes property tax cap. That's not what I'm referring to here. What I'm referring to is Florida's really peculiar descent and devise laws, who you can leave your homestead to at your passing. If you have your homestead in a will or in a trust, that goes to a standard marital or credit shelter provision, which we see many, many clients from up north have, that's actually an invalid devise under Florida law, and there's some really adverse consequences to that. So that's one of the reasons you want to make sure that your documents are updated. Now, you may know that Florida is a beneficial tax state. We have no estate tax, the state level. There's always the federal estate tax and federal gift taxes and those sorts of things. But from a state level, we don't have any estate tax. We have no income tax. We have no intangible tax. There's no inheritance tax. But again, if you spend, a lot of our clients spend 6 months up north somewhere and then 6 months here. The trick isn't necessarily becoming a Florida resident. The trick is to avoid the taxing authority of your former home state. And that's something that we're going to go into in our initial consultation. Now, aside from that, there's some other items that you want to make sure are updated. Florida's laws are different than every other state's, so you don't want any unintended consequences because your documents don't comply with Florida law. Now, it's not that they're invalid. A properly drawn will in Ohio, for example, is valid here in Florida, but it might be subject to a different type of probate, or it might have, there might be some unintended beneficial consequences. So that's a big reason why you want to update your documents to Florida law. Now, yet some other considerations that you want to think about and that we'll talk about during our initial consultation is whether the disability provisions are what they should be. In many files that we look at, they don't have the disability provisions that we think are important for our clients. You want to implement protection for the surviving spouse if you are married. You might want to protect your children and grandchildren from future divorce, from creditor issues, or those sorts of things. Many of the wills and trusts that we look at don't go into that. And this goes into, by the way, the difference between wills and trusts. Many of our clients are a little confused over what those differences are. A will, you might know, is subject to the probate process. Now, probate has nothing to do with taxes, actually. Probate is a process under which if I have an account in my name and I die, my will is admitted to the probate court and my personal representative, that's what we call an executor here in Florida, my personal representative is appointed, and then we file an inventory, what's subject to the probate. We file accountings, we clear my creditors, we pay taxes, and finally the assets are distributed to my loved ones who are named in my will. Well, that's a public process. Anyone can go down to the court and read my will after my death. They might even have access to my inventory. So in today's age of cybersecurity and identity theft, wills are really not the preferred choice of estate planning for anyone who has any degree of wealth, whether or not you're subject to the estate tax. So what you really want to do, especially when you have a Florida plan, is to have a trust if you have any degree of net worth. And why is that? Because trusts are private. Trusts are not filed with the probate court. Trusts are not made public. And that keeps everything private and within the family. So that's a good reason to consider trusts if you don't already have one. If you already have one, again, remember that your trust might be subject to the laws of a different state, and we want to make sure that there are no unintended consequences. Now, one final thing we're going to talk about in this short video is funding. Now, what do I mean by funding? What I'm talking about there is the actual transfer of your assets from your name, or you might hold assets jointly with your spouse, to your revocable living trust. Very, very important, because if I have never transferred my assets to my trust, well, guess what? I'm going to have a probate process on those assets at my death anyway. I might as well not have a trust. So those are the things we're going to talk about in this video, and that we're going to talk with you about during your initial consultation.
So one of the first things that we want to address when we're updating your estate plan is disability and disability provisions. The trusts typically do a really good job at addressing death and death concerns, all the probate avoidance language, but we also want to avoid guardianship. And we do that a couple different ways. First off, we need a clear definition of what is incapacity. We're going to be considered incapacitated if we are unable to effectively manage our property or financial affairs. Now, that's a very broad definition, so the next logical question is who decides that for us? That's our disability panel. And so our disability panel is going to be our loved ones, usually our wife or our kids or our family members, who we trust to say, okay, you cannot be your own trustee anymore. It's time for the next trustee to take over. Now, that next trustee is what we call our disability trustee. This is the person who is going to manage your affairs for you while you're still alive. Commonly, it is the same person that takes over after you pass away. We call that the death trustee. But it doesn't have to be the exact same person. You might have one person that would be better fitted taking care of you while you're alive, and another that would better taking care of the taxes and everything else afterwards. So the final thing here is we want to make sure that we're very clear to the disability trustee what they're supposed to do with your assets while you're still alive. And their sole responsibility is to you at this point. Even if that exhausts the estate, they are not to start trying to save money or starting to give assets away or do things that they would want to do. They need to do things for you and for your benefit.
So next, let's talk about protections for your surviving spouse inside of your revocable living trust. Your trust doesn't protect you from your creditors. That's because the trust essentially is you. It uses your Social Security number as a tax identification number, and you can take assets out and put assets in, at your discretion. So trusts are not protected as to the grantor, the creator of the trust. But you can protect the assets, the inheritance, for your surviving spouse. So everyone knows some stories. One of the most famous ones is J. Howard Marshall and Anna Nicole Smith. And you may remember that he was a Texas billionaire. He actually met her in a Houston strip club. And she eventually became the heir to his fortune, a second, third marriage. I don't know which number that was for him. But in any event, what you always want to make sure of, and what most of us want to make sure of, is if you pass away and your surviving spouse remarries, one of the concerns of many of our clients is that while you want your spouse to benefit from your assets, from the inheritance, from the trust, or from the will for the rest of the surviving spouse's lifetime, you also don't want those assets to go to some other family. Most of our clients would like to see those assets go down the bloodline. So there's some things that we can put into the trust that ensures that. And believe it or not, many of the trusts we look at that come to us that have already been drafted, many of the wills that come to us that have already been drafted, don't contain those provisions. Now, another aspect that you might want to consider about when we're talking about protecting the surviving spouse is who's going to serve as that spouse's trustee. And it might be the surviving spouse, him or herself. But let's think, for example, let's consider If you are the party who's always paying the bills and you're managing the investments and something happens to you, let's say you pass away, does your surviving spouse actually have the wherewithal? Does he or she have the knowledge? Does he or she have the experience to do all those things that you're doing now? Well, I've written a book on that subject. It's called Selecting Your Trustee. And that's something that we can give you as a valuable tool so you can know various aspects. You can think about maybe some things that you've never thought about before, other options that you've never thought are available to you. This is what we're going to open the door. We're really big on education here with our clients. We want you to make informed decisions. So protecting your spouse from all sorts of dangers, everything from remarriage to perhaps unscrupulous investment advisors and so forth, those are all things that you want to consider. For those of you in blended families, now that poses another additional problem. Your spouse might not be the mother or father, the parent of your children. And here we have some other considerations because we have a push and pull. What we have here is a surviving spouse wants income and assets for his or her life. The kids realize that every dollar that he or she spends is one less dollar that they will inherit one day. So these are things that we want to be very, very particular about what your intent is, who's the most important beneficiary to you, or how you want these diverse interests balanced. Those will be things that we consider in our initial consultation.
Now, after we've addressed protection for the surviving spouse, the next issue is protection for the beneficiaries, the ultimate beneficiaries, the kids, the grandkids, or anybody else that might be a beneficiary. So most of the trusts that we review are simple outright distributions. I pass away, we pay the bills, we pay the taxes, and then we give the assets to my children. The problem with that, though, is if there's a divorce, if there's a lawsuit, if there's a bankruptcy, a malpractice, if anything bad happens to the child after I've died and they've received my inheritance, well, that money is going to get exposed. That money is going to be exposed to the family member. And so there is a way that we can create a mechanism to provide some level of creditor protection to them, and that would be through the use of trusts. So instead of giving my child my inheritance, whether it's $100,000 or $200,000, whatever it is, instead of giving you the money, I give you a trust that has the money in it. Now, this is a very special type of trust. First off, it is an irrevocable trust. That sometimes is a little bit scary for folks, but this is an irrevocable trust that they are in control of. They are the trustee. They are in charge of the investments. They are in charge of the distributions. They are in charge of when to take it out or when to leave it in. They get to say where it goes when they pass away. They get to leave it to whomever they want. Again, with all of all of the client's input in designing it. But for most of our kids, we just leave it to them in trust. They're in complete control of everything, but I've pulled just enough strings so that if they get sued, if they get divorced, if they have a creditor problem, it's technically legally not their money because it's in this irrevocable trust. Now, this is something that they can't easily do for themselves. We do a lot of asset protection for doctors and lawyers and physicians and business owners and those types of things. And we've got to go to exotic jurisdictions, offshore, different states to try to protect their own funds from their own creditors. We're talking about you protecting your assets for them, somebody else. And that's what allows us to do this creditor protection under Florida's Trust Code.
Now, one aspect of your estate planning that is often overlooked is what we call funding. I alluded to this earlier. Now, what is funding? Funding is actually transferring your assets, transferring your bank accounts, transferring your real estate, transferring mutual fund accounts, brokerage accounts. We want to put them into your revocable living trust. Now, what a lot of firms do, and actually we did this several years ago, we used to hand our clients a funding instruction sheet where we'd say, here's how the title of your account should be listed. For example, my name's Craig Hirsch, so mine would be Craig Hirsch trustee for the Craig Hirsch trust dated whatever date that I signed my trust. And we would leave it to the clients to actually go down the bank, go down the brokerage house, and transfer all their assets. Now, here's something that we discovered over the years, is that our clients either didn't do it or they didn't do it correctly, or they didn't keep up with it. So we do it now as part of our process. So here's what you have to know about funding. One of the things we're going to ask you to do is to bring in copies of your bank statements, of your brokerage statements, your real estate deeds, and we're going to actually help you transfer those accounts and those assets into your trust. Now, don't worry. A lot of clients say, oh my gosh, I won't have any access to those assets anymore. That's not true. You're always going to have access to your assets because you are your own trustee typically. You can do whatever you want with the assets just as before. You can buy, you can sell, you can trade, you can withdraw. There's nothing that prevents you from doing all the things with your own money, with your own assets that you do now. It's just a different form of ownership. But again, if we haven't transferred all your assets into the proper basket, then we're going to have problems at your passing or in the event of your disability. We want your estate plan to be ready for you when it's needed the most. And this is one of the key ways that we do this. Without the funding process, well, again, you don't have a real good trust. It's not funded. So that's something that we're going to go over with you. We actually have a funding meeting that we're going to do with you once we're engaged as your attorneys. And that is one less thing that you're going to have to be worried about. Aside from the transfer of your accounts, you're also going to have beneficiary designations. Many of us have individual retirement accounts. We might have a 401k. You might have life insurance policies, annuities. Well, those all fit into your estate plan just like everything else. And again, this is something that's often lacking in an estate plan because this is something that you might have done just with your broker or on your own or on the internet. But believe me when I tell you that a well-funded trust and a well-funded plan also includes consideration of your IRAs, your life insurance policies, and your annuities. And again, this is something that we're going to help you take care of.
So one of the final things that we want to address when updating the estate plan is how do we keep this up to date? How do we maintain the estate plan? Our philosophy of estate planning, it is not a one-time event. It is not something that I do 5, 10, 15, 20 years ago, put in a drawer and forget about because so much is changing. The laws change. You're going to change. The assets are going to change. The beneficiaries might change over time. And so we want to make sure that the estate plan changes along with all of that. It's important that it's up to date today because you never know what's going to happen. But it's more important, I think, that it's up to date when you need it the most, which is hopefully years and years in the future when you pass away or if you become incapacitated. That's when it needs to be correct. And so we came up with a maintenance program. And it's our way to keep all of this up to date. So every year, our promise is to let you know about any changes to the law and make sure that the amendments get made. We invite you to tell us about any changes that have happened to you, your family, or your assets so that that can get incorporated in the estate plan so it really never goes out of date.
So let me walk you through what we call the Family Estate and Legacy Program, which is our unique process designed to give you comfort and clarity when updating or creating your estate plan. Now, there's 7 steps to this process. The first step is your client organizer. So you'll be filling out this client organizer that we're sending you, and it's very, very important that you fill it out completely, and here's why. A client who has a lot of IRA assets, we might give different advice to than a client who has a lot of commercial real estate. A client in a blended family, a second marriage with children of different families, we're going to have different advice than a client who has been married for a long time and the children are all of that marriage. So the organizer is kind of a pain to fill out, just like your CPA's client organizer. We'll admit to that. But again, it's really important. If you don't fill out the organizer completely, we don't know what kind of advice to give you. It's kind of like when you go to the doctor and you say, hey, this really hurts. And the doctor asks you, well, where does it hurt? And you say, guess. So, it's in order for us to give you a diagnosis, in order for us to help you, in order for us to prepare the best estate plan that's right for you, right for your family, and right for your situation, filling out that client organizer is very important. Now, the second module of the Family Estate and Legacy Program is the Goals and Responsibility Conversation. Now here it's going to be really important for us to delve into what your goals are. What are you trying to achieve with your estate plan? And not only that, not only are we worried about what happens at your passing, we're also worried at what happens during your disability. If something should happen where you can't manage your own affairs anymore, or God forbid, if you should have dementia or have Alzheimer's. So those are the things we're going to talk about in the goals and responsibility conversation. And again, we point you to our books, the Florida Residency and Estate Planning Guide, as well as selecting your trustee. Those are two books that are very, very valuable that will give you a lot of insight so that when we have this goals and responsibility conversation, it's at a much higher level than if you hadn't had these books to review and these other materials to review. The third module of the Family Estate and Legacy program is the design module. And here's where we actually put everything together and we design your estate plan, whether it's a will, whether it's a trust, and what type of trust is it? Is it a joint trust with your spouse? Is it an individual trust? Is it a married individual trust? Are you going to put in the protections for your spouse and for your children that we talked about in this video? Those are all the things that we're going to talk about in the design phase. The fourth module is the document builder. Here we prepare your legal documents, and what we're going to send you is a flowchart and a summary of your documents so that you can easily understand what your documents say and what they'll accomplish. We'll actually go through the complex trust with you in great detail during our meetings. You don't have to worry about understanding all the legalese, and we don't put legalese in there to confuse you. What we really need, though, we need to say things a certain way in order for you to get the benefits of the law. So that's one of the reasons why we give you a flowchart and a summary to review. We're going to spend time reviewing the documents with you, making sure that they comply with your intent, and you'll have every opportunity to make whatever changes to the initial drafts and the drafts that we create for you. The fifth module is the advisor coordinator. Now, you might have an attorney up north that you have a lot of confidence in. They might be a friend of yours. If you want to include them in this process, either by video conference or by telephone conference, we're happy to include them. You might have a CPA or tax return preparer. You might have a trust officer, financial planner, a trusted relative or friend, anyone that you consider your advisor, that you want to be a part of this process, we will happily include them because our goal is that you have comfort and clarity in everything that we do. And if you have somebody that you rely upon, we don't want to exclude them from this process. We're happy to include them however you want us to include them. So let us know in our initial consultation who you'd like for us to include and their contact information. Now, if they can come in, obviously, if they're local, we can bring them in. But if they're not local, we can always conference call them in. The sixth module is funding, and we talked about that earlier in this video, so I'm not going to go into that in depth again. Just know that you're going to have a funding conference with one of our funding assistants. It's a very thorough conference. Our estate plans are very thorough because of that. And you're going to have a lot of comfort, a lot of clarity that everything's taken care of. So the sixth module is where we actually get all the funding, the transfers of the assets into your trust, as well as the beneficiary designations to IRAs, to life insurance policies, annuities, and those sorts of assets. Finally, the seventh module is our maintenance program that Mike had talked about earlier in this video. So again, I'm not going to go into that in great detail. What you should know is that you get 1 year of our essential maintenance program for free. It's part of what you pay us for the whole plan. And then after that, we have an annual charge for the maintenance program. Now, you can choose not to go forward with the maintenance program, but I will tell you that almost all of our clients who are eligible for the maintenance program do sign up for it and do continue in it. It's a cost-effective way to keep your plan up to date with the tax laws, with the trust laws, with changes in durable powers of attorney, healthcare statutes, living wills. We'll keep everything up to date for you. Now, you also might have some things that we don't know about, and that's one of the things a maintenance program is key on, and that's if something changes in your financial situation or something changes with your family, and you'll let us know on an annual basis, and we'll see if we have to adjust your estate plan for it. Now, making a proper investment in your estate plan is one of the most important things that you can do for your loved ones. Now, we realize that fees are a sensitive issue, so that's why we're going to give you a range of fees for the different levels of service that we offer. And keep in mind this, you can choose everything from a basic plan all the way up to a very complex plan. It's all up to you. And after you visit with us, and keep in mind that your initial consultation is free, you'll have a better idea of what you want. We're not going to pressure you to choose any one plan. You're going to select which plan is right for you and your family. You're going to have a fixed fee for that plan. So what that means is that there's no worries about being on the clock. You know, if it takes us many more hours than we expected to complete your plan because you want to go through things, you want to ask us questions, you want to ask the attorney questions, you want to ask our funding assistant all these questions, it's very, very important to us that everything is right the way you want it. So let me review the fees for you and the different levels of planning, and we'll do this again in our initial consultation, and we'll give you a fixed fee quote. Here's just the ranges. We're going to actually give you a fixed fee quote for what your goals and aspirations are for your estate plan when you meet with us. Now, a lot of clients ask, well, how much is this going to cost? And that's a very reasonable question. It all depends, and you all know that lawyers sell more Depends than CVS and Walgreens combined, but nevertheless, it really does depend upon your situation, and I'll give you some ranges here. We do offer a basic plan. Now, the basic plan doesn't include funding. It does not include maintenance. It does not include several of the aspects, protections for your spouse and protections for your children that the higher levels do. But we do have a basic plan, and it starts at around $2,750, but it does include the revocable living trust. Whenever you have a trust, you will also have a pour-over will, and that acts as a safety net, catching the assets and putting them into your trust. You'll need a durable power of attorney, Florida-based durable power of attorney, Florida-based healthcare surrogate, and living will, with a few other documents that are very important. So that's the basic plan. Now, when we get in the Family Estate and Legacy Program plans, now we have 3 different offerings. The first level of plan is a foundational offering. Now, what the foundational offering does, it does a complete wheel. We do the funding. We have the advisor coordinator. You can get in the maintenance program. We're going to do the design. We're going to have the goals and responsibility conversation. Now, the foundational plan, though, does have at one point an outright distribution to either your spouse, your surviving spouse if you're married, or an outright distribution at some point to your children or other loved ones. It's not a continuing trust, so it won't protect those individuals. Now, the fees will depend largely upon the level of plan that you have within the foundational plan, whether you're single, whether you're married, whether you're going to have, if you're married, if you have separate beneficiaries or the same beneficiaries. And the general range of fees for the foundational plan is between $4,500 and $9,000. Now, the next level of planning above the foundational plan is the signature plan. In the signature plan, we're actually preparing not only a marital trust if we have a surviving spouse, or a credit shelter trust, or a generation skipping transfer trust, depending upon your goals. But we also have continuing trusts for your children. Now again, your children aren't going to have to go to a bank to beg for their money. We can make the child as their own trustee. But what we're doing here is we have continuing trusts for the children or other loved ones that continue on for their lifetimes. And it's protecting these assets from a divorce, from a potential creditor, from the bad things that happen in life. Even if your child is successful, let's say you have a successful doctor, lawyer, business person as a child or other loved one, it's really important to protect the inheritance for them. Why is that? Well, they might have a malpractice case against them at some point. They might get into a bad business deal. They might actually get into a bad car accident and be found at fault, and their auto insurance might not cover it completely. So those are the sorts of things that the signature plan will take care of that the foundational plan won't. It protects the next generation from those maladies. The fees for the signature plan can range from $6,500 all the way up to about $11,000. And again, it depends upon whether you're single, whether it's going to be a married joint plan, whether there will be a married plan with separate beneficiaries, and the complexity of the plans will all govern the fees. And again, we're going to give you a solid fee quote when we're done with our initial consultation. You can decide whether or not you want to move forward. Now, one aspect that the signature plan does not govern and does not protect that you might want to protect are your IRA, 401k, and other qualified plan accounts. Now, because those have income tax ramifications, you require some complex income tax planning because you want your beneficiaries to be protected from a divorce, you want to be protected from a malady like a malpractice case or a car accident or some other thing that can affect them. With the IRA accounts, with the 401ks, these are called income with respect to a decedent accounts. They're a little bit more complex. So with our highest level planning, which is a transformative plan, not only do we have the revocable trust and the pour-over will and the powers of attorney and all those other things that we have, but we're going to have a separate trust called a retirement plan trust that takes care of these assets. And we usually have special beneficiary designations that go along with those. So when you're doing the transformative plan, you get everything that the signature plan gives you, but you are also getting the IRA planning. The fee range here can range between $9,000 and $15,000, depending upon, again, the complexity of the plan, the complexity of your family, and your goals and desires.
Thank you for spending your valuable time with us. We hope this video has been helpful and informative when you think about your estate plan. If you've already scheduled an appointment with us, we look forward to seeing you soon, and we ask that you complete your organizer and get those documents sent in to us. If you haven't scheduled an appointment yet, we invite you to do so. You can call Gina at 239-334-1141. You'll get a copy of Craig's book, the organizer, and all the information. We look forward to hearing from you soon.